Hello, my name's Paul Henton. I'm a barrister here at Quadrant Chambers, specialising in commercial law for international clients. One of the first things an international client will want to know when a claim form lands on their desk is, can I challenge jurisdiction? And that is the title of my QBiT talk today. Can I challenge jurisdiction? How do I do it? The procedure for challenging jurisdiction is set out in CPR Part 11, but it's a very short provision, and most of what I'm about to tell you today is not actually in there. But what follows is everything you need to know. First thing you need to know, and this is in CPR Part 11, is you need to file an acknowledgement of service indicating an intention to challenge jurisdiction. Do not tick the box indicating an intention to defend. Do not engage in arguments with the claimants on the merits. Do not take any other step in the litigation other than preparing your jurisdictional challenge application, because a party who is deemed to have accepted English High Court jurisdiction or to have submitted to the jurisdiction will fail in a jurisdictional challenge. Next, prepare your jurisdictional challenge. You don't get much help on this in CPR Part 11. What you need to do is prepare an ordinary CPR Part 23 application with a supporting witness statement. Now, to compile this, you'll need to know whether your client was served out with permission of the court or without permission of the court. Let's focus on the first of those, with permission. There will have been an ex parte application by the claimant determined on the papers leading to the grant of permission to serve out. What you need to do is get hold of all the application documents which were put before the court at the ex parte stage and scour them, because those are the things that you're going to be responding to in your jurisdictional challenge application and evidence. Now, your evidence for your application is going to need to address three things. First, jurisdictional gateway. Second, the merits threshold. And third, discretion or forum non-conveniens. And a win for your client on any one of those three should lead to a successful jurisdictional challenge and an order that the proceedings are dismissed or stayed for want of jurisdiction. So let's look at those in turn. First, jurisdictional gateway. So these are the grounds on which an English court can grant permission to serve out. They're listed in CPR Practice Direction 6B, Section 3.1. There are at least 25 separate gateways at the moment if you count up all the subparagraphs. So you've got contracts made in the jurisdiction or made through agents here, or tort claims where the damage is said to have been suffered here, or injunctions to restrain acts here, parties who are said to be necessary and proper parties to litigation already taking place here. So there's lots and lots of different grounds. And at the ex parte stage, the claimant will have had to identify which of those gateways it says it can jump through and it says are invoked. So your evidence needs to challenge that and needs to address them. Now, what's the relevant threshold? The threshold is the good arguable case, but that's not the same as the good arguable case threshold that you see in the context of freezing injunctions. Rather, what it means is that there is a burden of proof on the claimant to show that they have the better of the argument, or sometimes it's said much the better of the argument, on the material available at the moment before the court right now that the gateway is involved. The adding of the word much comes from the case of Canada Trust and Stolzenberg, and it's sometimes called the Canada Trust gloss. So let's take an example. Let's take Gateway 6C, which is contracts made within the jurisdiction. So your evidence there will need to show that the claimant does not have the better, or much the better, of the argument that the contract was made here. Bear in mind, this could be the only time in the litigation where the issue of where the contract was made is actually of any relevance at all. It might never come up again. It might not be a relevant factor at all. So go to town on it. If you've got a contract allegedly made by email, attach the full run of correspondence. Try to identify the email which you say is the acceptance of the offer. Identify the place of the servers at which that email acceptance was received. And what you're looking to do is frame the evidence to show that that acceptance took place not in the jurisdiction, or at least that the claimant doesn't have the better or much the better of the argument as to where it took place, and doesn't have the better of the argument in favour of saying that it took place in the jurisdiction. Contract concluded orally. Second of the three things I said we have to address was the merits threshold. All that means is that the claim has to have a serious issue to be tried on the merits. So that's a low bar for the claimant and correspondingly a high bar for you. It's effectively the same threshold that you'd be looking to surmount if you were bringing a strikeout application or reverse summary judgment application. So not every case lends itself to this. And if you don't have the evidence that allows you to strike at that threshold, move along. As I said, success on any of these three should lead to a successful jurisdictional challenge. But if your evidence justifies it, go for it. If you don't succeed, well, you'll be able to run all those arguments again at trial on the lower balance of probabilities threshold. So it's almost a free hit at trying to strike out the claim on the merits. The third of the three things I said you need to address is that of discretion, forum non-conveniens. So this is an argument that the court should not exercise whatever jurisdiction it may have as a matter of discretion. The threshold test for this one is that the court has to identify the forum in which the case could most suitably be tried for the interests of all the parties and for the ends of justice. That's called the Spiliada test. For example, in your witness statement, you can look at where are the witnesses located? What language do they speak? Will they require interpreters? Is there physical property which the experts might need to inspect, like ships or containers of cargo or something? Where's that located? What's the governing law of the contract? So going back to our example of the contract which might have been made in the jurisdiction, so you might have failed on the gateway side of things, but a contract being made in the jurisdiction does not guarantee that it's going to be governed by English law. That question is governed by the Rome Convention, which gives applicable law to either a system of law which the parties have expressly or impliedly chosen, if any, or failing that to the place of incorporation of the party with the characteristic performance obligation. So if you're the service provider, where was your company incorporated? Was it in the jurisdiction? Or is really the centre of gravity of this dispute somewhere else? So those are the three things that you need to address. There's one optional extra, which in some cases it's appropriate to address, and that's the issue of full and frank disclosure. In every case, the claimant's application to serve out will have been made ex parte, and so the claimant will have owed a duty to give full and frank disclosure to the court. What does that mean? That means the claimant was obliged to bring to the attention of the court any matter which the other party, that's you, if you were represented, would have wanted the court to be aware of, going to those thresholds, going to the merits threshold, to the gateway, to the forum non-conveniens arguments. So when you're scouring the claimant's ex parte application documents, look out for any of those sorts of issues which the court ought to have been told about but wasn't. Perhaps there are points you raised in correspondence which you might have expected the claimant to say, the defendant has argued this, but as against that I would say as follows, but was omitted. And if, depending on the seriousness of the breach, if you can establish a failure to give full and frank disclosure by the claimant, this on its own can justify setting aside jurisdiction in its own right. Finally, let's look at cases where your client was served without permission. The main ground for service out without permission is for claims relating to contracts containing an exclusive jurisdiction clause in favour of the English High Court. That's CPR 6.33 brackets 2B brackets B. Trips off the tongue. How do I challenge in those situations? Well, we're still looking at the gateway. You might have an issue of incorporation. Perhaps you had a contract concluded by correspondence, so you'll be looking at the last shot doctrine, the battle of the forms. Was the exclusive jurisdiction clause incorporated? Does the claimant have much the better of the argument that it was? You still might have arguments at the merits threshold. If you say that the claim is amenable to strikeout, you can put that in. But on the issue of discretion, the hurdles are rather different because the courts take the view that they will enforce agreements to litigate exclusively in this jurisdiction unless there is a strong reason not to do so. What that means is that almost all ordinary forum non-conveniens factors, the location of the witnesses, the centre of gravity of dispute, are irrelevant. So you need something much more. One example which has gained some traction in some of the case law, for example, Donoghue and Armco, is cases involving multi-party litigation where enforcement of the exclusive jurisdiction clause would bifurcate the dispute. So there's part of the disputes taking place one place, but the aspect of the dispute which is governed by this particular contract has to be taken out of that and brought in a different forum. And that might, in an exceptional case, amount to a strong reason to allow a departure from the exclusive jurisdiction clause. So that, in a nutshell, is how you challenge jurisdiction. Thank you.